Hello, hello, hello. Hopefully you made it over here. Hey, Purple, Shield, did you actually use the redirect? I'm hoping that it worked. Ah, Mousy, you are not late. I was late. Actually, my other stream ran a couple minutes long. And so I'm trying to do them in two separate today so I can keep the Boone stuff ready for the hearing. I'm hoping. Hey, Anna, did you use the redirect? Hey, Juju, the redirect worked? Yay! Look at that. Because when it comes to big trial cases, I'm going to be doing this a little more often. Yes. You had to click on the screen to go. It did not work. Oh, I'm sorry. It should have just threw you over when I ended. Okay. But anyway, Sarah Boone's defense team and the state have been pretty busy. You know, we should have guessed that it was way too quiet that first day after the 27th when the Zoom hearing didn't go off and there was all that mess. I'm still having flashbacks to Mr. Owens going, Judge, 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 in the middle of everybody speaking because he couldn't hear anybody. Oh, you didn't use it? It's okay. Okay. Hey, Trees, you found yourself over here too. I'm glad to see everybody. I'm glad to see you all here. Thanks. All right. So, Sarah Boone. Okay. So, has anybody heard anything that's been going on? Yeah. I mean, we talked last week. After the hearing, it was kind of like not very successful. We all talked for a little while, but we didn't have the hearing. But then, Trial TV did the live, and we got some of it. And then we did get reporting on the rest of it from those that were in the courtroom that were doing the following on Twitter and stuff like that. So we do know several things that would happen. We do know that another hearing was scheduled, especially for the motion to suppress the interrogation at the Orange County Sheriff's Department, okay, at the office there. That Mr. Owens has been filing to try to get that suppressed, saying that her Miranda rights were not fully issued. And also, there is an order out on her makeup allowance. They actually want JAC to pay for her makeup and clothing. She can have JAC clothing. They made those arrangements, but apparently that's not good enough. So then I heard on a interview that the defense attorney is actually going to pay for her clothes because she doesn't feel that the JAC they're not making the proper accommodation for her, and they actually want them to pay for makeup. And well, I did post previously on the community tab, and in that hearing video, the motions actually that the state came back, they were quite snarky. One of the comments by District Attorney Jay was, so Sarah Boone would be the only prisoner in the state of Florida to ever have her makeup and hair paid for court. Like, that's how entitled this woman is. Okay. But they're going to try. This attorney, they're trying everything. Okay. On the one hand, I got to give them credit for really trying to get her out. But on the other hand, I just see them making things a little bit worse at the same time. But they're under a wire. They're under a time constraint. They're going to go forward with battered spouse syndrome, and they've been talking about that for a month. But in that hearing, we actually heard the judge ask it. He actually told, like, the hearing before, he said to the judge that they were going to go for self-defense. Now, the reason that it's such contention about this interrogation is he would like to get all of her statements thrown out, but he's really going to have a hard time doing that. He did say that, like, he did do, the state mentioned during that hearing that he had made 2 paragraphs behind another motion that wasn't really a motion. And then Owens kind of said, well, that was me just trying to secure that I would like the cell phone and the other Rodriguez, on-site interviews, motion to suppress, that I'll be filing them. I was just trying to secure the time. So in that hearing, Judge Kranick specifically told Mr. Owens, you need to you need to file your motion to suppress by end of day today, if that's the case. That whatever he had done was not enough. Now, granted, that day, no motion to suppress got filed. And there is reporting of everybody saying, well, then he can't file anything because he did actually find an amended suppression, but it's on the investigation. It's on the interrogation at the sheriff's office, the same one. It's amended to the other one. And he filed that a couple of days late. And I have that for you too. But we're going to start with, I think I titled this correctly. The state exactly is getting lit on fire here. They are actually trying to now get ready for whatever Owens is going to do, because he just keeps throwing things at them from left field. So even though he did not actually file a motion to suppress the particular interview with Sarah from Rodriguez on site, the state actually did a filing anyway. Okay. And I'm going to put that in the chat, and I'm going to get it up, and we're going to talk about it, because he actually listed it in the Miranda, in the actual Miranda motion, and he being Mr. Owens, because he actually did it that way. This is what compelled the state to actually respond. And let me bring this up. We don't need that anymore. No, we don't need that anymore. Well, we need this bigger. Okay. All right, we'll pull this up here. All right, it should be bigger again. All right. So let's start. So this came on the 27th, after, the 29th it got filed. Okay. This is state's memorandum regarding defendant's statements to Deputy Kayla Rodriguez and Detectives Coleswell and Lowen on February 24th. And this would be the day that they arrived. Okay. And the state wants to clarify some things from Mr. Owen. Okay. Comes now the state of Florida by and through the undersigned assistant state attorney and states the alleges. The deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 on the 24th, responded to the defendant's residence. Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings. One begins at 1:08 and lasts until 13:32 and lasts 13 minutes and 32 seconds. The next starts at approximately 1:22 and lasts 4 minutes 56 seconds. The final one starts at 1:30 and lasts 5 minutes and 30 seconds. At no time was the defendant in anything that resembles custody for Miranda purposes. And they cite case law, Ramirez versus State. The Ramirez case outlines the famous 4-factor test. This is what the judge will use in regards to Miranda, custody, and rights in regards to these interrogations. The manner in which police summon the suspect for questioning, the purpose, place, and manner of the interrogation, the extent to which the suspect is confronted with evidence of his or her guilt, whether the suspect is informed that he or she is free to leave the place of questioning. While Deputy Rodriguez would not let the defendant enter the crime scene, the defendant's home, to retrieve a soda or cigarettes, the defendant was not in custody. That's right. Sarah considered herself in custody because they wouldn't let her in her house. She was hanging like out. They never, they wanted to talk to her about the incident, but if she said she had something to do, they could have talked to her later. They just needed the crime scene. The deputy was a first responder trying to gather preliminary information about what might have happened. The defendant was spoken to on her porch and sidewalk area just outside of her home. She was not confronted with any evidence because at that time there was nothing to confront her with. The defendant was informed she was not free to leave the area due to the investigation, but the restraint of her freedom of movement never resembled custodial arrest. Just under 4 hours later, she was interviewed by Detectives Copsell and Lowen inside an unmarked car on the scene. Although under both Ramirez and Rincon, this is not custody for purposes of Miranda, she still gave her Miranda warnings. And which is good. She did that and safe. It shows good faith. Okay. For the reasons outlined in the state's response to the defendant's motion to suppress, the Miranda warnings were not defective, and her waiver of her Miranda rights was voluntary, and her statement were voluntary. Any motion to suppress on these statements would not be granted. And, that just shows that they are quite serious in regards to pushing back on having these actually tossed out. They, it is, you can see why the defense really wants them tossed, because we've seen those. We've heard those statements. We've seen those statements. And I have a video for you that I listed. It's from Mentor Law, which is like something deep dive true crime, I think he calls himself. And this is the video. And in this video, although it has some markings of his channel and all like that, he puts together all of these interviews and time tapes that they're talking about in both the car, at the house, and then back at the police, at the sheriff's office, at the Orange County sheriff's office. Okay. So he puts them all in one video, which I thought was really convenient for all you guys to refresh, because I don't know about you guys, but I heard her repeatedly say that they were having a good day. There was nothing going on. She was having an extremely good day with him, and that it was an accident. There was no intent. They were playing hide and seek, and there was no intent here. There's nothing. It's an accident. Owens keeps saying the state wants you to think it was an accident. No, it was Sarah's words that they were saying. The state does not think it's an accident. They're charging her with murder. They obviously don't think it's an accident, Mr. Owen. It's Sarah who put accident in the air as her defense when in the investigation over and over again as to why this happened. Okay. It was Sarah who actually wasn't very honest about her condition. It was Sarah, when confronted with the videos, didn't want to finish watching them, was horrified at what she saw and didn't remember. And when challenged why she didn't remember, like, well, you had a drink. You said you only had 1 or 2 glasses of wine, but you don't remember? And Sarah said she's not a drinker. She doesn't want to drink and she doesn't want to be drunk. That it was George. She says it even when she came for the second interview. Here's the problem. They don't want Sarah's words, because Sarah's own words are going to dismantle some of the battered spouse syndrome defense. Now, I will say that during the interview specifically at the sheriff's office, she did give a lot of information in regards to how contentious their relationship was, that there had been some aggression. She talked about, George unsettled life, and he had done things, but that he was doing things better. And that's the thing. She goes into this long tirade about how much better he's doing, that he's been attending the anger management classes, and that they've had no trouble between them for quite some time, for like a month or so. And that she was quite happy with how things are going and all of this. And so she's giving contrary statements to the police than what she is actually going to be conveying to her defense attorney and possibly to Julie Harper, who is going to come through as the clinical psychologist who says she has battered spouse syndrome in some form, according to the defense. Very, very odd. Okay. Now, we've already know that they cannot bring in George's arrests. However, Julie Harper can actually use all of that to actually convey whether or not, in her opinion, there was battery going on and whether actual Sarah has battered spouse syndrome. Okay, so it can be used in that way. But here's one thing that I noted in going over all of that. And I recently had to go over it because one of the other things that came to light in the last day or so is that the state filed a Brady's List notification that James O'Neill, who is one of the incident and reporting officers from a June 2019 arrest of George, okay, and Sarah actually called the cops on him, and they arrested George. There was obviously a mark on Sarah. Well, he's on the Brady list now, which means he's impeachable. And there's some credibility issues. Well, James O'Neill isn't really strong on the state side as a defense witness. Well, Mr. Owens did lead him because Mr. Owens listed every single one of the incident reporting officers that had any of the battery cases against George. And in looking at all of those, I did note that George Torres did not have any battery things like anything like this on his record until Sarah Boone. Now he has an ex-wife, but there doesn't seem to be any charges there at all with her. And he has children. It's not a very, according to Sarah in her interview, it's not a pleasant relationship between the exes, and that she causes him a lot of grief. But I couldn't find any battery, and I couldn't find any other charges on George Torres except for these ones that happened after he met Sarah, and they all involve drinking. In every incident, they're both drunk. Both of them. There are comments from the officers about it. Okay. It does get brought up in her interview. You did actually bail him out. You did actually drop the charges, and you went back with him the next day. I mean, in one incident, they put a restraining order on George, and she went to the court to get the restraining order removed and say no harassing content order instead. And she said, I still want him with me. Okay. Well, I just don't want him to harass me, and which I found, quite interesting. And then the very next day, the state dropped the charges against George for that particular case. Because after Sarah speaking with the judge and with prosecution in the court, they pretty much determined that they couldn't count on her as a witness against George. Without her support in the prosecution, they could still prosecute anyway because battery can be prosecuted, outside of it. But they just dropped it because it wasn't going to be winnable. It was going to be difficult. So he walked on that one. So it's interesting because she did give a lot of information, but at the same time, she was saying how bad he was. The detective kept saying, well, the day before you said you guys didn't get drunk. And yet today, now you're telling me he's a drunk and you don't know what he was doing. Like which is it? Were you guys drunk? Were you not drunk? And like every time they tried to bring up her inconsistencies or her trying to she would really get what are you guys trying to say? I could see why she feels that they pushed her because they did ask some very good, strong questions in regards to one thing that really bothered me is she said she would never zip anybody in a suitcase. And yet she just told them she zipped him in the suitcase. And we know about child services claim that she had done that with her child and was told and reprimanded and was told how dangerous it was. And yet she's claiming she knows nothing about anything like this just a couple of weeks later with the sheriff's department. So, there was a lot of inconsistencies there. Now, I'm not a lawyer, not a defense or a prosecution, not even a judge, just looking at all this stuff. But I find it horrible that George is here to defend himself. And I'm hoping now Brian Boone is listed on both the state's and the defense's witness list. And Brian Boone, actually, in the first interview, you can hear him say that Sarah was often the aggressor in their relationship and that when she drank, she got physical, abusive. She scratched, she kicked, whatever. And that he had to hold her back, several times. I mean, you know, she's not mental, is she? No, she's according to everyone, she passed competency, and they've had plenty of. Julie Harper's been seeing her since 2021. Mauricio, the second attorney, Mauricio Padillo, actually hired Julie Harper, and she'd been seeing her on and off. And then she was rehired by one of the others. I think it was either uh, Frank Bankowitz or I know Cashman wanted her back. Frank Apples or Hobson, one of them got her on board again. And so it was quite easy for Owens. She's had multiple visits with Sarah already. But you asked this question. It is like at the hearing, the Judge Cranick did approve the state's motion to demand that Sarah Boone sit with their clinical psychologist expert. Yep. To be clear, because if she's going to go battered spouse syndrome, she's going to have to prove competency. Okay. And she's, also that they have something to go with, and she has to sit for that, for that examination, a full examination as it was. So that was interesting also when that came through. Let me get back to the comments and pull that one off. The state ain't wrong. I don't blame them. And there's more, Juju. Wait till you hear what happened next. Okay, so let's see. Let me just recap. So we went over their pushback on why Miranda's not going to work. Okay, now Miranda writes, there's nothing that says that you have to read it word for word. What it does say that there has to be a good understanding between the officer or the law enforcement and the person that they're talking to, that they have rights and what these rights are. And if you listen to the interviews, you hear Sarah acknowledge that she understands and she's willingly doing this. Okay. And the second time she went back when she was arrested, she willingly went to the police office with a list of questions for them because she wanted to get her phone back. And the reason she couldn't get her phone back was because they now got a search warrant for it and they found everything that was on it. And they knew that if she didn't come up with a good answer for this, she was going to get arrested. It was looking a little more like something bad happened. Okay. And they're allowed to do that. There's nothing wrong with them doing that. Okay. And it really kind of gets my goat that Owens actually is inferring that there is. No, there's not. No, there's not. Okay. Yes, she's presumed innocent in a court of law, but on the investigative process, what cops look at everyone like they're innocent? No, they're looking for evidence. They're looking for investigators trying to piece things together. They're running scenarios through their head. It's not like that. And Mr. Owens knows that. And he's just giving me these shady vibes that I just can't shake. But we'll see. It's going to be a lit trial. I'll tell you that. It's definitely going to be a lit trial. I know, Fish Nerd, I didn't pay attention. I'm sorry. I'm sorry. Yeah. I don't know. All right. Let me get to the other documents that I have for you. Yup. Juju, you're going to love this one. Juju, are you sitting down? This one literally floored me. And let me switch things out. I'm doing a lot of reading today, but I got to say it's fun because this was lit. Like this one surprised me a bit, but I can't say I wasn't here for it. Okay. All right. So, unfortunately, we didn't get to see the defense's filing. And the only reason we know the defense made this crazy filing is because of this response from the state. For whatever reason, sometimes when Owens files something, depending on what it is, it goes behind, it has to be manually entered, and stuff doesn't hit at the same time. He could have also filed it under seal with the judge. We're not sure. All I know is it wasn't on the docket when I looked, and I looked earlier this morning. It's been 5 or 6 hours since I looked. It could be there now. But at the time I pulled, it wasn't. this on the 30th yesterday. The state's request for a protective order. Yep, that's what I said, Juju. Sit. I hope you're sitting because you're going to fall over. You're going to fall over. This one's good. This one's really good. So comes now the state of Florida, Mr. J again, and he's hot with this defense team. He's like had it with them. Okay. Here he comes, representing the state of Florida, and through the undersigned, states the following: the defendant, in her third amended witness list, has listed the following air quote people as witnesses: the custodian of records of Orange County Office of the State Attorney, domestic violence supervisor for the Office of the State Attorney, Ninth Judicial Circuit of Orange County, the victim advocate supervisor for the Office of the State Attorney, Ninth Judicial Circuit, Orange County, misdemeanor supervisor for the Office of the State Attorney, Ninth Judicial Circuit, Orange County. The state requests a protective order under Florida Rule of Criminal Procedure because anything these witnesses could say about the defendant and the decedent, meaning George, would be protected by the work product privilege. Florida Rule of Criminal Procedure 3.220 G and L. If the defendant wants public records from the state attorney's office, she should do whatever everyone else has to do and file a public records request. Ouch! Burn! Blind! Jay is pissed. I don't know. Maybe you don't find it as amusing as I do, but I was waiting. Everybody's been so patient with them. I was waiting to see, because I knew that he was going to go in. You like the sounds of where it's going? In other words, these are all people that work for the states, the district attorney's office, in the records office and everything. And they actually want us to put them on the witness list to come in because they don't want to take the time to order the records and everything. They just want to ask them questions like on there. And you cannot do that because they're all involved in the state's case and it's all work product because they work for the state. They're not part of law enforcement. These are the custodials of records, Juju. This is like, when I say that Owens has got this lazy, like, let everybody else do the work for me kind of attitude, I mean, somebody who brings two paralegals to sit with Sarah Boone at the table and nobody can answer when a certificate was filed. What's the date on the certificate of filing? When did you send this motion? Owens didn't know. The call-in attorneys, Beck, Henderson, they didn't know. There was the two paralegals just sitting pretty at the table. Didn't even offer to help him. Didn't even pull a thing. And we know they're not real paralegals because there hasn't been a single I take that back. There was one. Most of his motions have no case law at all. The only motion to date since he came on that has case law is the hair and makeup one. I kid you. I hope you're sitting down. I kid you not. I mean, I don't want to be persnickety and a little like defense judgy, but we've seen some amazing defense teams out there, right? We've seen some yokels too, but damn, they at least put in an effort every day. I mean, we all got annoyed with John Pryor, right, at Daybell? But damn, did he do his filings? Yes, he did. Did he cite case law? Yes, he did. Did he try repeatedly to give the judge something to prove his point that he could go to? Absolutely, because he knows that's how you get it done. Mr. Owens, no. He's like, I'm not ready to argue that yet, Judge. Then he goes and refiles it, amended, and still doesn't put any case law in there after being told to his face by the judge, you're giving me nothing to go by. What case law? What are you referring to? What backs this up? I'm not ready to do that yet, Judge. I'll get back to you. And then when he gets back to him, still, zippo, nada, zilch. If I was Kranek, I'd be tilting my head at him a little bit. But Kranek's fair. And I'm going to have to channel my Judge Kranek and be a little optimistic that Owens does a little bit better in front of the jury. Because in front of all of us, I don't know about you guys, but thumbs down, Mr. Owens. I don't think you're helping here. But you do. What can I expect? You're Sarah Boone's attorney, willingly. And you wanted it. You asked for it. You got it. Toyota. Like, what am I going to say? You know? Anyway, it continues. Subjecting prosecutors and their staff to this type of discovery of their investigations would require disclosure of work product and seriously impede criminal prosecutions. Case law, Egan versus Egan v. DiManio, okay, Florida, 1974. We believe the trial court was right the first time in denying the pretrial defense efforts to subpoena the two state attorneys and inquire into oral communications, sworn or otherwise, between them and a state witness. We didn't even know that was going on. Cranick kept that zipped. Whoa. The oral and unrecorded statements of witnesses to a state attorney are privileged as work product and not subject to discovery. Olson v. State, Florida, 5th District, 1998. See State versus Rubin, Florida, 3rd District, 1986. Case law, case law, case law. I love it. That's State versus Rubin, sorry. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of their client's case. Opinion work product is an absolute or near absolute privilege. Horning, Keaton versus State, Florida 5th District, 2001, which cites Rabin. Fact work product concerns what the attorney did and what they learned in their role as attorney. As the name suggests, fact work product is factual information which pertains to this client's case, prepared or gathered in connection therewith. I don't know. Is that Idaho? No, indicated at 444, citing Rabin again. Same case, State versus Rabin. The fact work product is discoverable only if the parties seeking this work product show the court the need for the fact work product to prepare a party's case, and that without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. The state is at a loss for what non-privileged testimony any of the air quote people listed above could provide in this case. Therefore, the state is requesting the court to enter a protective order to prevent any employee of the state attorney's office from being a witness in this case. And it was served to all of them. And this is William Robert J. And get to know that name. When Mr. Cacciatore is not there, Mr. J is there. And Mr. J has met his limit. He was waiting on the docket for stuff. He's looking through the docket. He is well want a continuance. Okay. And he's been on the clock all week. All week. Mr. J. Thank you, Mr. J. Anyway, that link worked. Anyway, Juju, were you ready for that? Oh my goodness. This makes no sense to me thus far, but I like the sound of where it's going. Yeah, did you like where it ended up? The state is so over Sarah Boone, and more so Sarah Boone's ego. Exactly. And it seems like that ego has now been dispersed into these other attorneys that she's got working for her. Because I got to tell you, Owen's just walking in there with that kind of ego, thinking this is going to be a cakewalk. Well, it's cake, okay, but I don't think it's walking. I don't think it's walking. Oh my gosh. I thought her trial couldn't get better, but I was wrong. It keeps getting better. I mean, when the state has to actually request a restraining order on you because you're out of your mind. Like, Whoa. And maybe they don't think he's out of his mind. Maybe that's like a normal thing to do in some cases. But no, I have never seen this. Like, if there is a particular incident, like let's say in the Murdaugh trial with Becky Hill, could those court appointed people get like subpoenaed in regard? Of course they could. It involved the jury and it involved her duties, and she was involved in the incident. But these people just doing their jobs, filing the reports and doing their summations, nope. I mean, the records person, the custodial of records. Yeah, I don't know. I don't know. It is. It is. It is so good. Juju, I would have loved to have seen Sarah try the case herself, but this is fun as well. It is, but because actually this is Sarah trying the case, only with help, because they're actually doing what Sarah wants. You can, I mean, can you guys see it, right? Look at the filings that have been made. This is she's telling them what she wants. I have no doubt. Speculation on my part. I haven't heard from Sarah. Believe it or not, her and I aren't phone buddies. I gotta tell you, it's what it looks like to me. She's definitely directing the show here. As a no, and let me be fair. As a defendant should. It's her life. It's her case. Okay. But only Sarah could do it like this. Like this is good. This is good. Yeah. Oh man. Sovereign citizen Sarah. You know what? She does have that little bit of a vibe, but she wouldn't like it if we said that about her, Anna, at all. She would fight against it. She would give us like 27 reasons as to why she's not, while she acts just like it. Like, you know what I mean? Women is like, yes, she would. I know. What? Citing case law? Oh no, I know, right? How are they ever going to get through the motion, Juju? They cited case law to back it up. Now, Judge Kranig's going to love it. And so is his court clerks. But this will confuse the defense. I hope the state sent cliff notes for them. I hope they didn't. Let them struggle. Like, honestly, this guy, I mean, that's the thing. Owens expects the cliff notes. He expects you to hand him everything, like pour him. But Judge told him from day one, you knew what was going on here. You met with her 4 days before you decided to take this on. You even went to the state and tried to work out a deal before you took this case on. You knew what you were in for. I'm not moving the date. You know what you've got to do. It's up to you to do it. I am not moving dates because she got an attorney. She was told that a month ago. It's on the file. It's backed up by case law, which is probably, like you say, it's something that confuses Owen. I don't know. Did he forget how to do it? Did he ever do it? Like, I don't know. I don't know. The more I look into the defense team, the more discouraged I get. I stopped looking. Nothing I found was good. And I don't want to disparage attorneys. It's all from the past. But man, none of it really looks good. None of it really is good. Especially the fact that he wanted to bring Dr. Michael Birkin on as a crime scene investigator and death investigator. This is a former medical examiner in Florida that was fired, in Missouri that was fired, and he was doing autopsies on the side, getting paid for it, which is not illegal, and he can do that, okay? But what you have to do is actually provide the report, which he didn't do, which is a violation there. And also, they found a storage unit where he had body parts from those autopsies stored. He kept body parts. None of them from the Florida office or the Missouri office, but the ones he did privately. He kept brains and hearts and stuff without the permission of those that he contracted with to do the autopsies. And he lost his medical license in both Florida and in Missouri for not doing reports on the job, for sloppy this, for autopsy reports that weren't done while he worked for both Missouri and for Florida. It was, yeah. So it's no wonder he's not the expert witness anymore. But they're still allowed to use him as a consultant to Julie Harper. Like, she's allowed to talk to him about stuff. and get ideas. He'll be consulting with the team, but he's not getting paid by they pulled everything for JAC. Now I don't know if JAC gave them a phone call and said, we're not going to pay for anybody who's not licensed. How can you be a death examiner when you can't be an ME? You know, those are normally medical examiners. You can't be a medical examiner without a license. Okay, and so it's a little sticky wicket there. Could he be a crime scene investigator? Sure, he could. He could recreate the crime scene. He could even talk about his experience when he was licensed. I'm just saying, it just gave like if he was up there, it gave the state so much to go with, right? As far as credibility. I don't know. I know. Which part about the crime scene investigator and the death yeah, I get it. Like and I was actually horrified when I found out, and I didn't want to report on it because I wanted to make sure it was all solid because it is in the past, but still, like, come on, could the team get any shadier? Oh my god. Oh, it says it's not available anymore. If you have the name and or link of the channel, that would be great. Okay, hold on 1 second. The name of the channel is in the description. It's Mentor Law. It comes up as it comes up for me. Okay, hold on. This is the link for the video. Is that the link you're using? This is from the name of the channel. Mentor Law is a deep dive true crime. Hey, Wrecker. I'm just confused there, Shield, why it's not coming up, for the video. Okay. All right. Exactly. She is pulling a Midwest journalist move. Okay. Speculation seconded. Thank you. I'm sorry to be so speculation with you guys, but I just had to. The last document that I'm going to give you, I'm not going to read because it is literally exactly the same as Mr. Owens filed earlier, except for one notation that I will talk to you about. And that is in the beginning. In the beginning, he says, in the first paragraph, and that's what I'm just gonna read. Okay, hold on 1 second. Let me make it bigger, but I'm not gonna pull it up. Okay, because we already did that. Let me pull Juju's comment down so she doesn't feel like I'm picking on her. I'm not. Juju, I'm so ready for tomorrow's hearing, and they better, okay, they better be all live in chambers. But remember, in the last hearing, he actually said, Judge Kranick, being he, said that he would handle the makeup, hair, and restraints in chambers. But when he listed the hearing on site, it does have his courtroom 12, where he is. So I'm hoping that whatever was the private part, which would have been the restraints and whatever the sheriff's office had to say, if they did that ex parte, like, and got that taken care of, that's all cool because they'll discuss it in the hearing, whatever they can. I'm just hoping we still go live. I'm planning on it. I'll be here. We'll see. Okay. That lovely channel, Trial TV, is going to be doing the stream. They have somebody in the courtroom. We'll be looking at the threads to see what's going on. So hopefully everything, fingers crossed, goes well for that. But otherwise, we're still doing the trial either way. Okay. I'm glad that worked. You needed snacks? I'm almost done. I'm almost done. Okay. For some reason, I thought the hearing was today. I was so disappointed when I realized the error. Well, at least we got to catch up on this ridiculousness before we get more tomorrow, Juju. Like, we get more tomorrow. Like, just imagine. Anyway, the only difference in the amended motion to suppress that Mr. Boone filed on the 30th was, and this is what a lot of people were reporting, that this should have been in on business close on the 27th with the last hearing. But I don't think that's what Kranek was talking about. I think he's talking about the shady move he made that the state brought up about the other things, the Rodriguez and interrogation in the cell phone. And I think that's why the state filed what they filed, anticipating that he was going to do an amended, but he didn't. But his amended is only about the defendant's statements at the Orange County Sheriff's Office. Okay, and he says, comes now the defendant by and through the undersigned attorney pursuant to Rule 3.190 in Florida of criminal procedure. The Fifth and Sixth Amendments of the United States Constitution in Article 1, Section 9 of the Florida Constitution, and respectfully amends this motion, moving the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof state the following. And that's when they're going to go into the Miranda thing and all of that. But the only thing that changed was that he actually added the Fifth and Sixth Amendments of the, and I'm not going to cite case law, Judge Kranek. I'm throwing the state constitution at you, the United States Constitution and the Florida Constitution at you about Miranda. That's what I'm going to throw at you, because that's what he is, about criminal procedure, about interrogation. And he's trying to say that Sarah Boone was duped. Like Sarah Boone could be duped. Has he met her? Like, seriously. Anyway, everything else is point by point by point the same. Talking about, sitting in the green chair, appreciate you coming in. How is any of that wrong? He's trying to say she was coerced and that they didn't read the last part of the Miranda, and so everything should get tossed. I don't know for sure how that's going to go. I couldn't really tell you. I don't know. You guys want to make a bet? You're stealing the otter berries. Mousy, are you hungry? Thanks for feeding the otters there, Rick. Okay, AK guys. Let's just take a little poll, and then I'm going to sign off for the night. Okay. I bet it will not get tossed. I'm with you. I'm thinking that Judge Kranek has been giving it careful consideration, and I do believe that he's going to side on the four principles of Miranda and decide that Sarah Boone knew what she was doing. She knew she could leave. And until she was arrested, she actually could have stopped talking, requested a lawyer. She voluntarily signed a waiver to give over that phone. I think there's more leaning towards it staying in than coming out. Was it sloppy? Yeah, a lot of police officers and lawyers would say they would prefer that they read it all word for word. Okay. And that they weren't so flowery with their words, but they're allowed to do all of that. There's really no law against that. Yeah, and she was Miranda'd 3 times. In the car, when she got there the first day, and when she came back the second day. She was Miranda'd 3 times. I know, no, right? It didn't look like she was being pushed around. It did look like they were giving her leading questions, like they knew something. I will say that, but that's not wrong. That's what they're supposed to do. I mean, it's an investigation. Someone's dead. Sarah seems to forget that someone died, and that anything that they did were in finding out how that happened. And since she was the only one in the house, of course they're going to talk to her. They have every right to talk to her. It is not anything against her civil rights to be talked to. As a matter of fact, she would be required. They could actually get a subpoena and bring her in. Force her to talk. Get a judge to issue something to actually put her on record. It wasn't like that at the beginning. They were leading, but she followed. Exactly. And she kind of dug her hole. And the only problem with all of that is that it doesn't go with the defense that they now want to give. And this is Owen's problem. But that's his problem, not ours. And I can't wait to see how he handles it tomorrow. It should be good. I do believe that Owen and Henderson and Beck is off in Arizona somewhere. I don't know if he's even going to come in for the trial. We haven't really heard much from him. Henderson claims to be the one who does most on battered spouse syndrome. He was going to be talking much. But when he did talk to Judge Kranick, he also had absolutely no case law and nothing to talk about. It was grandstanding. It was definitely, and Judge Kranick's not about that. You got to come at him with the law. He's not there for the cameras. He don't care. He don't care. And except for when you don't fix your damn mic, like you better fix your mic. They better come. They better come ready this time. That's all I got to say. I don't want to see another canceled hearing, but we're getting up there, and I'll see you all tomorrow. Have a very good night. Thank you for hanging out and changing streams with me and everything, and for giving me some interesting comments and questions. I always appreciate it. And I am really looking forward to tomorrow, and I hope you are too. Okay. On that, good night, everybody.